Crime and Punishment team at Vidhi Center. Please give a big round of applause to him. The third panelist, we have Professor Dr. Sarafaraz Ahmed Khan. Sir is a professor of law and a former registrar acting at WBNUJS, Kolkata. If I misread the citation of anybody, I'm so sorry. This is the mistake of Google, not mine. Thank you so much. The next presenter with us who could not join was Professor Dr. Asha Shrivastava. She could not join because of her prior commitment, so in absentia, I have to introduce her. Last but not the least, the lady in the panel, we have Professor Dr. Dipa Dube. She is a renowned professor at Rajiv Gandhi School of Law of Intellectual Property Law, IIT Kharagpur. Please give a big round of applause for ma'am. Balraj sir will join in between, but it is my honor and responsibility. Yes, sir, to introduce in absence of him, but he'll join shortly. Sir is a founding Vice Chancellor of DNLU Jabalpur, and he was also the former Vice Chancellor of RMNLU Lucknow and NLU Bhopal. So sir will join us shortly with the...
Good afternoon, everybody. The topic of discussion, limit of criminal law. Already in our prior to inauguration, Professor B.B. Pandey touched the thing that what is happening in our society will be specific. If we think of Sutherland, there should be politicality, specificity, universality and sanction. But that limit is no longer we can continue because of the change of our technology and also the social perception and cross-border offenses, organized transnational crime. So the jurisdictional issue, the technological issue, all this, and the investigation and punishment, all issues now having a demand of relook or reimaging. With that, we will pass here, I think, with 5 minutes each passed, then we will give another round of reaction to other speak and open to also. Our time is 1 hour, we will try to complete it within 1 hour.
Sure, sir. Thank you so much, sir, for setting up the tone for the discussion. My first question is to Professor Sarafaraz, sir. Sir, the question is, does the excessive criminalization violate Article 21 of in the judgments given by Supreme Court of India? Because whenever we talk about over-criminalization, we looked up to Article 21. Is it so, sir?
Okay. Good afternoon, everyone, and thanks for organizing this program and inviting us. This is an important issue today, which we are going to discuss on over-criminalizations and linked with the Article 21. As we know, Article 21 consistently, which is unjust, any process which process is amounted to punishment, that cannot be a just process under Article 21, and hence is the violative of Article 21. Many times, this over-breath of these criminalizations have a chilling effect. And we are starting saying that many circumstances when regulatory framework has been brought into the criminal law purview, many things which are in civil itself criminalized. For example, throughout the history, length and breadth of the Indian history, there are adolescents who have sexual relationships. Now suddenly, at one go, we make every adolescent sexual relationships as criminal. Everyone become accused or criminal. So when law criminalized adolescence, so while it was the reactions up to a heinous crime which is a minor, but at the same time, branding every adolescent relationship as a criminal activities is definitely having a chilly effect on the impact what we see today. These are another aspects on what we see in the criminal justice systems today. And my impression is there is a large number of law where while we criminalize the perpetrator, we criminalize the victim also. I can give you several examples. For example, my area of work is on human trafficking. A large number of victims of trafficking being prosecuted under 14 Foreigners Act. When you look at the Transplantation of Human Organ and Tissues Act, under the act, those who given the organ, they is accused. Those who taken the organs, accused. There is a trafficker. Those who are taking the organ, they are the demand creators. But at the same time, we are equating them with the victims who in the difficult situation for some regions, they have given the organ allured by the others. So when a person who is allured by the others because of the
Point. Can Article 21, where right to life and personal liberty serves as a substantive limit on legislative overreach in criminalization, what jurisprudence supports this or challenge this particular notion?
I hope I'm audible. Yeah, thank you very much for the invitation to speak today. I agree that Article 21 can most certainly be used as a substantive as well as a procedural limitation on criminalization. The due process requirement does that for it, and it has been used. So, the court in Navteej Johar, the court in Joseph Shine, used an interpretation of Article 21 to say that life with dignity, personal autonomy, are central to the right to life and personal liberty, and therefore constitutionally protected ideas. And constitutionally protected ideas cannot be criminalized. And I think that's a very clear pronouncement by the Supreme Court that Article 21 can most certainly act as both a procedural as well as a substantive limitation to the power to criminalize. The Delhi High Court, the J&K High Court have also done so in context of beggary. Begging was decriminalized in Delhi, in J&K, I think both benches presided over by Justice Geeta Mittal, that in a very, very simple interpretation of Article 21, that it means life with dignity. And in a context where the state is mandated to ensure that a right to life is meaningful, is a life with dignity, one cannot criminalize poverty, one cannot criminalize begging. So I think in both these cases, the courts have very clearly laid the principle out. But unfortunately, the courts have also, in some instances, used 21 to uphold criminalization. And I think one of the more concerning places that they have done so is criminal defamation. Right to reputation has been read into right to life, most certainly is. Defamation is one of the reasonable restrictions imposed under Article 19 on free speech. But the Constitution nowhere says that this reasonable restriction should attract criminalization. We are one of the few countries, of course, who have continued to use the colonial framework around criminal defamation. And unfortunately, as the legislature often does, we reach out to criminal law to solve out of our issues. We reach out to criminal law to solve out of our issues. The court...
Or you can enlighten us with this.
Hello. Okay, thank you so much. Right. Thank you so much. So it's probably a mix of both, where you have had a rationalization. Probably in the morning speech, when he spoke of that the government had thought of Nyay as being to the criminal justice. So probably that itself reflects that central to their interest was not, imposition of penalties or penalization, but the idea that how to deliver better justice, if I can say so. But probably, just some pointers. The simplification which has happened in terms of the language used, many of the outdated archaic terminologies, even offences have many of the outdated archaic terminologies, even offences have been removed. There has been the grouping of offences under different heads and elimination of redundancy of obsolete provisions of the law. That one part of it. So that also shows towards a sort of a rationalization, that's the prominent trend. However, in discussion many times what we have seen, if we say an expansion in a negative sense, for many offences there has been an enhancement in terms of punishment. So that has been a matter of immense concern, that if we wanted probably justice, if we wanted a lesser application of the custodial sentencing, because now you have community sentencing, and the same breath if you are enhancing punishments for many of the offences, probably there may be a slight contradiction. So yes, that's why I say it's both about rational.
So it is critical for criminal laws to remain neutral in the way, one, they are conceptualized, in the way they are written, as well as in the way they are enforced. Unfortunately, in both these cases, we see this disparity, that they are both conceptualized to criminalize certain sections of the population, but also enforced in a way that they criminalize marginalized sections of the population. We carried out a study in 2018 here in Mumbai. We found that almost everybody that was charged with and convicted of offenses under the NDPS Act were small-scale cannabis users from the streets of Mumbai. And this was a study of 10,669 cases, and we realized that over 95% of these people were picked up from the streets of South Mumbai. They were charged, arrested, produced before the court, convicted on the same day. And we didn't find even a single case where somebody was convicted of possession or consumption of high-value manufactured drugs that account for the most number of drugs that are seized. So who is this law targeting? Who is this person that is getting arrested and prosecuted, and who is scot-free? So I think that remains true. The second point that I highlighted was the way in which we conceptualize crimes, the way in which we conceptualize criminal offenses. And I think Professor Sarafaraz rightly mentioned in the beginning that we have seen this happening in the colonial times, where laws were targeted. Not criminal laws, the sole purpose of criminal law was not to solve the public order, law and order issues, but to also further the colonial administration's social, economic and political goals. And that unfortunately has withstood the test of time and continued post 1947 as well. And we see that even today, where criminal laws are used as instruments of social and political control. The Maharashtra cabinet yesterday clearing the anti-conversion law. We've seen laws that govern food preferences, laws that deal with civil matters, especially these laws where there is a reversal of burden of proof. Every conversion is illegal unless proven otherwise. So I think these are the cases that really tell you that there are concerns in the way that laws are conceptualized, laws are implemented, and like everywhere else in the world, the most marginalized communities bear the brunt of it.
Thank you so much. You have rightly discussed not only the selective enforcement-based choice, but also given rightful examples. Continuing to this, my next question is to Dipa ma'am, where we all looking at the changes in the digital world and looking at the crime rate in the digital world. Ma'am, my next question is to you. In the era of digital harm, where we are talking about cyberbullying, AI-enabled crime, should criminal law expand, or should we invest more in regulatory, civil or technological safeguards?
Okay, thank you for the question. The thing is that, the underlying understanding with regard to when to use and how much to use criminal law, I think that should remain the same in terms of being a law for the last resort. So not every sort of a cyber, harm or cyber incident should make us, or the, constant in present day where we are speaking of a lot of AI related incidences, the general understanding or the discussion I've seen is always how can criminal liability be brought about. So probably, yes, where there are serious harms, when you are speaking of, different cyber stalking, cyber harassment, and there may be many other serious harms included, there definitely it should be conceptualized as a crime, and the law should be developed in a way which takes it in the form of criminal liability. But the emphasis, nevertheless, should be beyond in terms of regulatory, right, in terms of technological safeguards. So I think the answer would lie there in terms of how we can do a in some of the specific type of cyber harms, etc., where there is a certain level of seriousness, gravity which is identified, we definitely need to look into that for the purpose of reading it within the domains of criminal law, but not, our instant answer should not be for every violation. The criminal law should not be an answer. So we should be able to balance and see our responses more in the civil domain than in the criminal law.
I have a question.
Uh, sure, sir.
When we are saying that there is over-criminalization because of nature of crimes being changing because of technology, jurisprudentially, can we think that our actions to criminal liability, which are in the BNS, not much change from our traditional principles, whether that required to relook, that sometime exceptions due to some circumstances, the digital divide we acknowledge. So digital divide puts our people universality, law will be applicable universally to criminal law. But the technology digital divide, whether something to be done for the people who are ignorant of technology, or some type of criminal liability, whether we can jurisprudentially think on that. What is your reaction?
No, I have a slightly different view. I don't think we have a crisis of criminalization because of evolving technologies. We have a crisis of over-criminalization because we can't think of ways to enforce laws other than criminal laws. There are 7,305 ways one can be prosecuted for under only union laws. This number would go up to 20, 30, 40,000 when we account for state laws as well. And 75% of these laws have nothing to do with criminal justice system. They do not involve BNSs, they are not the POCSOs of the world, they are not UAPAs, they are not all of these laws. These are laws that govern the day-to-day functioning of the society, the day-to-day of how we go about living our lives. Why should a sweeper go to jail for not informing his boss under the NDMC Act? There is a 3-year jail term, I think a 2 to 3 year jail term ascribed for it. Why should any one of us go to jail for missing our tax deadline? There is a mandatory minimum jail term. Why should any one of us go to jail if we are addicts of any narcotic drugs and psychotropic substance? So,
in that case, it is the legislative tendency where
Absolutely.
there is a failure on the control of crime.
Absolutely.
There is a tendency to have criminalized the law.
Absolutely.
That's a trend, I think,
So the problem,
particularly in our country.
problem is a problem of plenty, and probably the easiest way, and that's also a way of it's on. So it's a problem of plenty, and I think as a part of a political and a government, we always prefer to, try to get the confidence and public support through the use of the instrument of criminal law. So we think that by way of coercion, suppression, people will be much, satisfied in terms of the end result.
Sarafaraz, sir, question is to you. Eh? Bhaiya, it might do.
Yeah. So I have the same view, like what N. K. Chakrabarti sir said. I think in the digital age, we got a new category of persons, so new kinds of illiteracy, which are technological illiterate, many times we can say, and digital illiterate, which can, many times people might, by mistake it happened. But then, there are many such circumstances where the peoples who share the informations on the internet are culpable amounted to hate, culpable amounted to something wrong. So if something for giving some kinds of impunity when something accidentally or due to illiteracy happened, there is a requirement which the court can only judge. But in the cases where there is absolutely it's a hate, then there is a need for protection because we know where the hate can lead us. And so digital, in the digital sphere nowadays, the problem comes that in most of the legislation somewhere it is a erosion of mens rea, and we are all adopting on the strict liability principle. So like it's the other party can say why they have done, whether it's done by ignorance or not, which many times proving negative will become very difficult. So one suggestion could be what sir has saying, that a certainty of punishment. So we require certainty of punishment, and then the digital age we require changes. So we do have come from the age of your Indian Evidence Act to Sakshodhiniyam. Drastic changes are there. Many changes are really for the citizen centric, which might have some kinds of a potential challenge will come. Not able to reach them or law.
Agreeing, sir. But yes, in coming future, we'll try to solve those challenges.
Of the BNS. You don't even need to prosecute anybody. You can put them in jail for on preventive basis. So I think a lot needs to be done on preventive detention. A lot needs to be done on procedural aspects to ensure that bail becomes a matter of right and not something that is discussed in conferences like these.
Business.
Yeah.
Thank you.
Now I think we can open it. Time is only 15 minutes.
Yes, last questions to both the panelists, sir.
Now we open it.
Okay, sure.
Put the
As
questions to panelists also.
sure, sir. Okay, sure.
Put the
As
questions to panelists also.
sure, sir. We'll move to the open house discussion with this note. We'll move to the open house discussion with this note. If the audience has any question to the panelists,
Was addressed at some point, but I mean, even with the new BNS, we see a lot of inconsistencies in how punishments are prescribed. I would give you an example of buying a child for prostitution and selling a child for prostitution. Both have different punishments, which is 10 years and 14 years. Under the ART and Surrogacy Act, abandoning a child in one law is an imprisonment of 10 years, and in one law it's just fine. So it's just, I mean, the more you read about it, you find how absurd it is. So just wanted to understand as of now.
Have identified as serious on grounds suddenly to impose very high punishments for that. And that has been an anomaly, that where the level of punishment, they have suddenly become very draconian. So I remember same Professor Pandey, I think in a previous conference saying 1 step ahead and 2 steps back. Because somewhere you have tried to bring about, we are trying to do away with the coloniality of it, and then we suddenly also become, very tough in terms of saying.
So on one hand, we have one of the most important purpose, that is to protect the person from himself. That is why the NDPAs and these laws are there. On the other hand, now, since the panel is discussing and the reflections are that instead of treating the person right as a criminal, treat the person as a victim, because many of the people who are undergoing mental trauma and stress, they are consuming the drug. So how do you balance out both the situation? On the one hand, we have the purpose of criminal law to protect, for example, wearing helmet, seat belts. On the other hand, we have the different perspective where the the person who is a wrongdoer is a victim also. So how do you balance out?
So I request Naveed to answer this.
Yeah, I think it has fundamentally to do with the citizen-state relationship. Can you hear me now? Yeah. It is fundamentally to do with the citizen-state relationship. How does the state see the citizen? Unfortunately, we continue to see our citizens like we used to 150 years ago. We want to ensure that we are present in each and every aspect of that citizen's life, how they go about, what they eat, and what drugs they consume. And if they don't, then we have a punishment prescribed for that. And this is what we call the paternalistic view of, criminalization as well. And I think it's time to relook at this aspect of things, and it plays out very differently in different aspects. Drugs is just one issue where we feel that, from the ground tell us that this is something that needs to go. But the Uttarakhand UCC tells that why does one need to register their live-in relationship? And if they don't register their live-in relationship, they go to jail. So the enactment of the amendment to the Companies Act, the LLP Act, the thrust that we need to do be trust-based and not focus on punishments. Then movement towards courts decriminalizing adultery, decriminalizing homosexuality. Then the government again with the Jan Vishwas one pushing the of trust-based governance over, punishments and focus on deterrence and, forcing people to do things. And I think that is where the real mindset change is happening. It might today be happening because of ease of doing business, but tomorrow it will certainly happen because of ease of living. And I think that's where the role of the civil society comes in, to really identify and pinpoint these issues so that it becomes a part of the larger reform effort. But I really think that the movement at the level and across states has really now gained momentum.
My question is, the panel theme is, do we need limits on criminal law? The statement underscores that there are some limitations. Are there any limitation? Can it be imposed? Does the plenary power be justified on the ground of security? Sir mentioned about
protection.
The ground of security. Sir mentioned about
Protection also.
Public order.
So.
Public order, reasonable restrictions also. Should we find it in philosophy or the normative theories? And if yes, which theory of criminalization then we should adopt? Thank you.
Dipa will say theory. What principles of criminal law to limit? I think the limitation is we have this balance of interest which our sociological thinkers, when we are making a law, we know that there are some constitutional things that discriminatory justice, affirmative action and discriminative justice. But overall, we have actually balancing some interest also. That's why question of sanction in our corporate law are increasing in many, particularly corporate fraud. The total cost of property offences and total cost of corporate offences, the whole country, the property offences and the only corporate offences, corporate fraud, 4 times the property offences. So we have to think the social conditions also, that what is happening, what are the changes, social conditions, that also, because it is not that law will static. According to situation, sometimes the punishment or sanction by sometime public opinion, sometime the government policy, sometime even the government treaty obligations make the changes of this punishment or criminalization. These are sometimes also the government policy influenced by globalization or
With the decriminalization effort at the union level and state level, and I think there is a concerted effort to